Did you know that for the majority of the history of this country and the state of Texas, that you didn't have the right to delegate the authority to make your medical decisions to someone else? You couldn't have someone else make a decision for you, even if you were disabled for medical decisions. Well, I think the reasoning behind that, and I didn't know this, was that people thought for many years it was too personal of a decision, it was too important of a decision, and that you just couldn't give that to someone else because you should be the only one to decide what happens to you in medical situations and choices. Well, the 1980s rolled around. People started to really be talking about in medical conferences and medical communities how we really needed to have something in place that allowed someone else to make your medical decisions, at least in situations where you were disabled and could not communicate on your own. Well, 1983 rolled around. California was the first state to pass laws allowing medical powers of attorney, and it was actually in 1989 that Texas passed their first law allowing durable powers of attorney for medical decisions. 1999 rolled around 10 years later, and Texas changed the name of the document, updated the law. We started calling it a medical power of attorney, which is what we still call it today. And Texas started to allow, at that point, even out-of-hospital do not resuscitate orders and medical directives. Some people call those living wills. Well, the law changed again recently, and in January of 2018, Chapter 166 of the Health and Safety Code says that now there's some language that's required, and you have to substantially comply with that language to have an effective and legal medical power of attorney. Well, why would they do that? The best way I can describe this is imagine that you're disabled and maybe your children take you to the hospital and there's no standard on what counts as a medical power of attorney. You can have one, there's just no standard. You could have written one page, you could have written 100 pages, and because there was no standard for many years, what would happen is the hospitals had to then send the document off to a legal department had to interpret it, and all the while you're potentially waiting on someone to find out if this other person's allowed to make your medical decisions, and you need medical assistance. Well, the medical community petitioned to get the law changed to where there was more of a standard, and they were successful. And the reason was, from my perspective, that really from the front desk all the way to the physician and everybody in between, now we can know whether you have a medical power of attorney and proper medical directives immediately, because there's this substantial compliance with the required language in the Health and Safety Code. So you have to ask yourself the question. Number one, do you have a medical power of attorney in place? It's not something people could do even just a few generations ago, so you should get that in place. And if you already have one, is it up to date with the 2018 changes?